order the Martin County Code Magistrate hearing for January 15th, 2025. If you'll all rise, join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, please be seated. All right. I am going to try and make sure that I take everybody that's here first so that we can get you all out of here, and we'll have more cases other than in addition to the folks that are here. So I'm going to call the first case, which is respondent is Lawrence H. Grubb and Dana Collins, and it's ENF 2024-010023, and it's alleged violation of permitting under Section 105.1 of the Florida Building Code. And good morning, and I see you are represented, sir.
Yes, sir.
Okay, if you make your appearance.
Good morning, Your Honor. My name is Joseph Grasso, attorney here in Stewart, representing the property owner, Mr. Grubb.
Yes, sir. Welcome to the proceeding. All right, this is a violation hearing. We're going to hear from the county. If they make a prima facie case, burden will flip to you as the respondent, and then we'll go from there. I won't even bother. I'll swear you in later, assuming that the county's made their case. So let's go ahead and listen to the county. Officer Counselor, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, and whenever you're ready, you can begin.
Okay. My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Lawrence H. Grubb, as a representative of the property, is present. The case concerns a property at 3364 Southeast Ellendale Street in Stewart, Florida, which is located within Martin County. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Lawrence H. Grubb, Dana Collins, and Teresa Collins. A copy of the property appraiser's record of ownership is County's Exhibit 1. On January 26, 2024, I inspected the property for an expired permit application for a application for BLD 2023-050-659 for a carport. What I observed was that a carport had already been completed without a permit. The expired permit letter is County's Exhibit 2. At the time I photographed the property, the photographs accurately show what I saw then as County's Exhibits 3 and 4. 3 is a carport in question, over here to the right. County Exhibit 4. Just another view of the carport.
Okay, and those are photos that you took?
Correct. Based upon the investigation, I issued a notice of violation to Lawrence H. Grubb, Dana Collins, and Teresa Collins on February 2nd, 2024, marked as County Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 105.1, Florida Building Code, permits when required as adopted by Section 21.1, General Ordinances of Martin County, to obtain a permit for the carport. In the notice of violation, the respondent was given until March 4th, 2024. To correct the violation, was informed of the need to contact Martin County Code Enforcement upon doing so. On February 12th, 2024, the owner applied for a permit for the carport, which is permit application BLD 2024-020-504. A screenshot of the permit is County's Exhibit 6.
Okay, and what's that screenshot telling us?
That's basically saying that upon getting my violation letter, he did start the process to get a permit for the carport.
All right, and I would tell you it's almost impossible to see it there, but on the computer that I've got in front of me, I actually can read it.
Okay. And basically, at the time, the status was waiting on the applicant.
All right, so it's, all right, so it's a residential screen room or shed or carport. Waiting on applicant. And that was dated
This was for back on February 12th, 2024.
Got it. With you.
Okay. Exhibit 6. I have met with and spoken with the property owner on several occasions, granting extensions in order to give him the time to obtain the permit for the carport. As of July 22nd, 2024, the permit was denied by zoning for not meeting setbacks. Since compliance was not achieved, the owner was sent a notice of hearing by certified mail on August 27, 2024, for the September 18, 2024 hearing. It's marked as County Exhibit 7. The owner requested an extension because he had requested to go before the Neighborhood Advisory Council Board for Golden Gate to request alternative compliance in order to keep the unpermitted carport. In December, the Neighborhood Advisory Council Board referred the decision back to, the decision of making an alternative compliance back to county staff. So since compliance was not achieved, an amended notice of hearing and a notice of violation was issued by certified mail on January 2nd, 2025, and is marked as County Exhibit 8. The return receipt was not received in time, so on January 3rd, 2025, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 9 and 10. 9 is my posting, 10 is my affidavit of posting. Therefore, I went to the property again on January 14th, 2025, and saw that the cited violation had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then. It's marked as County Exhibits 11 and 12. 11 is the carport still stands. A different angle. And a screenshot of the permit status is County Exhibit 13, which is, the permit is currently still in review, pending the decision of whether or not the county is going to grant alternative compliance for not meeting setbacks for the structure.
Okay, so it's currently in review. That's 1 through.
It's in review, but it still hasn't passed the zoning requirement. So even though the status is in review, as of the last record for the Martin County is that it's been denied its zoning approval, so.
So the Golden Gate Neighborhood Board sends it back to staff, and what does staff do with it?
Staff is making a decision of whether or not they're going to grant the alternative compliance. But their last decision on the case was that it was denied.
Okay, but it's still in front of them. There's no final.
It's back in front of them. The first time it went through them, they denied it. So then they tried to appeal for alternative compliance, and that's the part that's currently pending.
Okay. So why shouldn't we wait until they make a decision? What if they say, yeah, that's fine by us? And I don't know who on the staff would do that, but suppose the development director decides that it is fine, then there's no violation, right?
If the permit was issued, like, as I said, I'm just going by the last decision the county made was that they denied the zoning review.
Okay,
So the permit's not issued. He's been given the option of taking it down also, so.
okay, but it's kind of a catch-22. You can't get a permit unless you get the zoning approval, and so,
And there wouldn't have been a case if he hadn't built it without a permit.
got it. I understand.
Yeah.
Yeah,
So it's just based off the length of the case. The case was started a year ago, so
okay.
it's been back and forth. So I request that all county's exhibits be received into evidence. Based upon testimony and evidence, I request that the respondent Lawrence H. Grubb, Dana Collins, and Therese Collins be ordered to comply with the cited provisions of the Martin County Code by February 28, 2025. And if not compliance by then, be required to pay the amount of $100 a day per day until the violation is corrected. The county has incurred the cost of $575 conducting this investigation. That concludes my testimony.
Okay. Mr. Grasso, any objection to my accepting into evidence the county's exhibits 1 through 13?
No, Your Honor.
All right, so without objection, that's so ordered. Well, I understand the county's position. They're looking at the technical violation of the fact that a permit was required to construct originally and was not obtained prior. So that's where basically the county is. What have you, do I need, I'm going to swear your witness in if you want.
Yes.
All right, sir, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? And your full name, sir?
Grubb.
And your address? Your address?
64 Southeast Ellendale Street, Stuart, Florida.
Okay, all right. It's,
Your Honor, if I may, we agree. Obviously, a permit was required. In Mr. Grubb's defense, not that's an excuse, but, the neighborhood's filled with carports. There's some confusion as to whether, this is temporary, permanent, and, all those sorts of things. I think the record shows that Mr. Grubb has made a diligent, good faith effort, ever since he received the notice of violation to obtain a permit. The violation was roughly around the 2nd. The application was made on the 12th. And as noted, the difficulty's been compliance with the 5-foot setback. I mean, that to leave the carport where it is, it's not possible to comply with the setback. And obviously, and also given the configuration of the property, there's no place to move the carport to comply with the setback.
let me ask you this. Look at Exhibit 11, if we can put that one up. And, yeah, expand it. The carport that is on the right-hand side of that photo looks like it's a kind of a temporary structure. Is it or is it not, Mr. Grubb? Okay. So, and if that were removed, would you meet the setback requirements?
No, sir, because they're telling me the carport has to be 5 foot behind the front of the duplex, which would be over to the, it would be to the right side, oops, excuse me, to the right side, but there's not enough property there to put a carport.
Okay.
This carport, I would like to state for the record, we purchased the property May 5th of '23. This carport was there when we purchased the property.
Both of them?
The-
I'm looking at them as two different structures.
The tarp one, my understanding, Your Honor, is that code enforcement can't do anything with these temporary carports. And they're all over the neighborhood.
But that's not an issue. The only one that is at issue here is the one with the metal roof.
Yes, sir.
That's it.
Okay. And the county's problem, and correct me if I'm wrong, county, is that it sits in front of the building instead of on the side of the building.
Correct, yeah, because of,
And there's no room on the side of the building for that structure, is that?
no, he has no, yeah,
Correct.
it's basically too long because of where the house is placed, because he can't move it back far enough, because
Right.
the house is there, so it's encroaching, the setback that it's encroaching on is the front one, which is why, and then because it's in the CRA, it's even shorter, so that's what's stopping it from passing review.
Okay, so the staff can't pass it unless, it looks like there's some sort of variance process through this neighborhood board?
Yeah, so basically, Golden Gate is under a CRA,
Yes.
and it has its own board. So in
Okay.
December, Mr. Grubb appealed to them, and the CRA board decided that they just decided not to make a decision. The decision that was made at the hearing was that they referred the decision of alternative compliance back to staff.
Okay, but does staff actually have the ability to grant a variance?
If I can weigh in just to clarify this a little bit, basically, the CRA is an appeal of the original decision that it's non-compliant, has to be removed. And their decision was, we're not going to, we accept that, we refer it back to them, we're not going to change it. So basically, it's not a start over again, it's just, in legal terms, it would be a denial of the appeal, the original finding stands.
Okay, all right, so, all right.
Your Honor, I disagree kind of with the characterization of what the Neighborhood Advisory Committee did. And I've got a copy of an email from the committee back to Mr. Counselor after the decision, or the no decision, where they elected, not to approve, not to deny, and said, essentially what they did is they said, we just need further guidance. I don't believe that they said, hey, we're sending it back to the county for, you guys make the decision. They said, well, we just don't have enough guidance on what we should be doing, how to handle this. And we can introduce this into evidence. I mean, essentially what we would like, I mean, we think I don't know that the permit was denied. I mean, I'm not, I just don't know that. But either way, we would just like sufficient time, for the county to respond to the request of the committee and have time to go back to the committee, with what the information and the guidance they requested from the county to seek for a decision or to seek an actual variance without the, because obviously Mr. Grubb's working to try to get this permit issued.
All right, may I see that correspondence?
Sure.
Actually, you can put it right down there, I think, and if we do this right, we can actually look at it, all of us look at it. Okay, so let's see. It is a,
You said yes.
all right, so it looks like they basically kind of kicked the can down the road. And if I understand her 3 points, her numbered points there, she's asking for some sort of legal guidance. Can a duplex outside the CRA have a carport and a driveway? 2, why hasn't legal, meaning county attorney's office, been involved? And 3, why are so many other carports with canvas or cloth awnings allowed to remain in place? So, I mean, it looks to me like that this isn't necessarily ripe for a decision from me. I mean, it would be easy for me to say, you built the thing or had it built without, or bought it that way without permits, and therefore you got to have a permit to install it, so you're in violation. That would be easy, but I'm hearing what you're saying, and it looks to me like you've requested some sort of an appeal, and that's not done yet.
Your Honor, we have somebody from Growth Management on call to testify and explain further, if necessary.
Do you think it's going to make any difference?
It'll clarify what the position, what the position is as to this communication, and where it is in as far as decision on,
Okay.
because they're the ones who make the decision.
So
Mr. Colando is seeing if he
13
was supposed to be
years, we
present
can
in.
Find somebody out in the hallway.
Yeah.
Okay, we'll wait a couple of minutes. If not, I'm inclined to just continue the case because, and maybe I continue it till February or March even, maybe the March hearing. And that would give you opportunity to either get it squared away or or make a decision as to how to comply. I can tell you that based upon the evidence, I would find you in violation if it came to that. But as I say, I'm willing to continue it based on what I'm hearing.
Your Honor, I'll give you a little history. So when I applied, after we bought the property, I applied for a 20-foot wide by 20-foot carport to get rid of the tarp carport,
Okay?
okay? After I applied for it, we did other stuff to the property, which is all permitted, metal roof, icing insulation, impact glass windows. Pretty much almost $100,000 later, I kind of, just said, well, the carport can wait. What I didn't know is to go over and close out the application. So when the application expired, that caused the building department to have Chris come out and see if I built a carport. This one that you're looking at was there when I bought the property. I'm sorry. So I was trying to get one that matches the one on the other side, which has been there since 2013. It's bigger, it takes 2 cars, and I could get rid of the tarp one. That's kind of what started this whole
Okay.
thing. That's pretty much, the story in a nutshell.
Okay, but
So you didn't build the,
No, that one was there. I was
which
trying to build-
which one was there? The one on the left?
Well, the one on the right, I have to keep putting a new tarp on it. They only last 6 to 8 months, but I tried to keep mine looking good.
well, they
Where,
were both there.
yeah, they had,
Okay, so, and you bought the property when?
May 5th, 2023.
Okay, and you believe that these were built in 2013?
Well, there's one not in the picture that was 2013, according to the appraiser's website.
Okay, all right. Good morning.
Good morning.
If you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and your full name and your position.
Peter Walden, Deputy Growth Management Director.
Okay, Mr. Walden, I understand you may have some insight into this situation?
Yes, this carport was brought to our attention by code enforcement. They did apply for alternative compliance with the CRA. It went to the local NAC, and they did not make a decision. They kind of put it back towards the director to decide whether or not we would grant that alternative compliance. The answer was no, that it does not meet the guidelines for that, and that's where we're at right now. It's been turned down for alternative compliance.
When I look at the email from, is it Joanne Laperta or
Joy Lepert, yeah.
okay, who's the chair of that committee? It looks to me like she's actually asking for guidance, not a decision by the staff, but guidance. Because I don't know that, can you tell me that the staff has the ability to either grant a variance or not?
You want to answer? Well, the growth management director, it's not a variance, it's alternative compliance to the CRA code, and the growth management director, as the code is written, does have that ability for everything other than building height and that type of thing, so.
Okay, so if someone wants to put a carport in front of the building, where it normally would be required to go on the side of the building, the growth management director could in fact grant that alternative compliance.
If it met other criteria as well, like being the same design as the house and that type of thing. So it's a metal carport like this would be problematic whenever it would be visible.
Okay, and then I guess ultimately, what I'm hearing is that there are many, many more of these in this particular neighborhood and community. Do you know whether those have been granted alternative compliance or no?
No, they have not. This is the first one in this area that's come to our attention. We do understand that there are other ones that have been out there for years. We respond to them when they're brought to our attention.
Okay. All right.
Your Honor, Elise Elder, Deputy County Attorney. If you want the code provision for the alternative compliance for the Growth Management Director, it's in Article 12 of our Land Development Regulations. I think it's 12.1 under the applicability section. And that lists the standard for the growth management director to grant or not grant alternative compliance.
Okay.
Excuse me, Your Honor. I'm not aware that a decision was made to deny it. I mean, as far as I know, the permit was still in review.
I don't, the email doesn't say anything
talking
about
the-
denial.
The
And you
testimony
don't,
was that it went back to growth management and was denied.
I think what Mr. Walden is saying is either it would be denied or they've made a decision somehow, but you haven't gotten any notice of that, right?
No, I think Mr. Counselor said the permit was still in review.
He did. He did. So,
According to our program, Acela, it is still in review. It hasn't been marked off yet, but discussions have been made with the director, and he has decided to deny the request.
okay. So until you get an order denying it or some notice of it being denied, it's still in review, basically. All right. So I was saying that it looked like the neighborhood committee had kicked the can down the road. And that's kind of what I'm going to do as well. Because until there's some final adjudication by the department, I can't tell whether, in fact, the violation will be allowed to stand or not. So and I understand you're telling me that the department is going to deny it, but it hasn't done it yet. And then the applicant basically has requested relief. So I'm going to move this to the March hearing. And by that time, you all should have figured out what your relative positions are. I've already explained to Mr. Grubb that based on the evidence and the evidence that I have in front of me, but for this issue of the incomplete decision regarding its location, I have enough evidence to find that a violation does exist. It was built without permit, and that's the simple, easy answer. So that tells you, you basically now have, 2 months to figure out what you're going to do, whether it's to take them down, whether it's to pursue the appeal of the growth management director's decision, or once you get it. But in any event, I expect that we're going to see this case back at the March hearing, and unless you've fully complied, which in this context is either you've got permission to do it or you took them down. Okay? Yes, sir. All right. Okay. All right. So I'll get you an order continuing the case.
I've got copies. That's for them.
Thank you, Mr. Walden. You're excused.
Thank you, Your Honor.
Okay, Mr. Grasso, I'll get that to you. Do you have a card that you can give me, or, here?
I don't.
We can do it the other way. Just shoot me an email, and I'll get you an order.
Thank you.
Thank you. All right. Oh, before you all go, Mr. Grasso, before you go, I'm going to mark that email that you gave us as Respondents Exhibit 1. Any objection? All right, so no objection to it coming into evidence. This is in evidence as Respondents 1. Okay. Okay. Interesting. All right, the next case is is the Casamento case. It's Sergio and Susan Casamento, case ENF 2024-120123. And the respondents were given a citation for engaging in a business without a license. And this is an appeal of that citation. So what have we got?
Go first or goes first?
I'm going to hear the counties first, and then I'm going to come to you. Okay, so if you, actually, you can all raise your right hands, if you will. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and your full name, sir?
Nicholas Michael Fisher.
Okay, Mr. Fisher, you're going to testify, and gentlemen?
Sergio Casamento.
Martin Silva.
Martin Silva. Okay, and what's your relationship here?
Just helper.
Okay, you work for Mr.
I
Casamento?
hired him. I'm paid.
He's the recipient of the citation, Your Honor.
Okay, got it. And it's Martin Silva. Okay. All right, let's hear from the county, and then we'll go to you. Go ahead.
Good morning, Your Honor.
Morning.
My name is Nicholas Fisher, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Martin Silva, is present. This case concerns the citation numbered ENF 2024-120123, issued to Martin Silva at 5273 Southeast Tall Pines Way, Stuart, Florida, 34997 in Martin County, Florida. On December 5th, 2024, I observed a wooden deck being built. I made contact with Martin Silva and the property owner, Mr. Sergio Casamento. The property possessed a homeowner builder permit with no listed licensed contractor on the permit. The property owner stated he hired Mr. Silva to help build the deck and was paying him daily for his work. Mr. Silva does not possess a valid contractor's license either through the State Department of Business and Professional Regulations or through Martin County. I informed them of the unlicensed contractor violation under Section 43.49 of Martin County's ordinance and issued Mr. Silva a citation for engaging into business/acting as a contractor without a license. Mr. Silva complied and provided his driver's license for the citation issuance. The property owner stated he would pay the citation for Mr. Silva the following day. The citation is marked as County's Exhibit Number 1.
Okay.
At that time, I photographed the property. The photographs accurately shows what I saw then and is marked as County's Exhibits Numbers 2 through 6. Exhibit Number 2, just a front-facing view of the property. On the left-hand side, you can see where the deck is being built. Exhibit Number 3, up closer view. Exhibit Number 4, some tools, lumber. Exhibit Number 5, just a photocopied, or a photo of the citation with Mr. Silva's ID that has been redacted just to show that it has been issued to him. Exhibit Number 6, just a closer-up view with the citation number and his redacted driver's license. I have also attached the submitted permit application and homeowner builder disclosure statement showing that no licensed contractor was added to the permit and that the homeowner understood that he could not hire an unlicensed contractor as County's Exhibits Numbers 7 and 8. Exhibit Number 7, the permit application at the bottom showing that no contractor's information was submitted. Exhibit Number 8, the homeowner builder disclosure statement. A copy of the written request to contest the citation are County's Exhibits Numbers 9. I request that all the county's exhibits be received into evidence based upon the testimony and evidence. I request at this time that the citation be upheld.
Okay. Mr. Silva, let me just ask you, any objection to the Exhibits 1 through 9?
I was just helping. I wasn't contributing to be. I wasn't contributing to be a contractor or a GC. I was literally just
Okay,
taking.
no, that's not what I'm asking. What I'm asking is, the county has presented Exhibits 1 through 9 in this case. Any objection to any of those?
No.
No.
Okay, so without objection, I'm going to accept into evidence the county's exhibits 1 through 9 in this case. And now that helps us so that we can talk about them. Do you don't reside on the property, right?
Nope.
Okay. And Mr. Casamento, do you reside on the property?
I'm home.
It is your home. Okay. And
I'm living there right at the moment? No.
you own the home. I understand that. I saw that from the property appraiser's
Okay.
report, but you don't live there.
Not at the moment. I plan on moving in.
Where do you live?
Boca.
Okay. All right. And I'm looking at, okay, so you basically applied for an owner-builder permit, which was granted, is that correct?
Correct. The permit is issued, and it is an owner-builder permit.
All right. And so, and Mr. Casamento hires Mr. Silva to help him.
Correct.
All right. So maybe I'm missing something. Where,
I would direct you to the owner builder disclosure statement, paragraph number 8, which addresses this exact situation.
I understand that I may not delegate the responsibility. That's paragraph 8?
That's paragraph 8.
Okay. For supervising work to a licensed contractor who is not licensed to perform the work being done. Okay. Mr. Silva, are you a licensed contractor?
Sir?
Okay. And any person working on my building who is not licensed must work under my direct supervision
Which he was.
and must be employed by me,
Which he was.
which means that I must comply with laws requiring the withholding of federal income tax and Social Security contributions under the Federal Insurance Contributions Act. So basically, you've got to be mindful of that, and must provide workers' compensation for the employee. I understand that my failure to follow these laws may subject me to serious financial risk. Okay, so if I understand this correctly, Mr. Silva, are you an employee or are you a contract employee? And do you do other work for Mr. Casamento? No? Only here?
Yeah, I just hired him to help me
All right.
Lifting, the moving.
digging the holes.
Nothing structurally.
So when I arrived at the property, Mr.
Yeah.
Silva was actively constructing the deck on the left-hand side. His brother was also present at the property working on the deck in the rear.
Okay.
Mr. Silva, when it states in here that you have to be an employee, that's a W-2 employee, and you have to take out workers' compensation insurance in his name. If you don't have that, then he's not an employee. So any help that you would then hire, as you've just stated, to help you build, construct, alter, any sort of work on your property that would be required to be constructed by a licensed contractor, you would need those things, otherwise he is unlicensed. If he does not possess a state license, for example, a CGC license, a general contractor's license, or a local license, say, to be a carpenter, that would qualify him to do the work without being a W-2 employee of him, in this case, for an owner-builder permit.
Okay, so let me make sure I understand the county's position. Say I'm in my 70s and I want to build a deck, and I have difficulty carrying lumber, And so I go down to the local corner and hire a day laborer. And I say, can you help me do this? I'm responsible for it as an owner-builder, but I need help. I can't do it myself.
They would have to be a licensed contractor.
Okay, but that person would have to be a licensed contractor.
Correct.
So I can't just go hire a day laborer.
You cannot. On a homeowner builder permit, you're taking on the responsibility to be your own contractor.
Yes.
For the purposes of pulling the permit. But anybody that you hire, that you have come onto your property to assist you in the construction of your project, if that project requires a licensed contractor to be able to do the work, that person would also have to be licensed.
Okay, that is much further than I have ever seen the law taken, as far as the county's position on this. Most jurisdictions would view it differently. Let me just say that.
Well, Your Honor, if I could weigh in as your hypothetical, there's a difference between hiring somebody to help you move some heavy objects and hiring somebody who's actually doing the construction work. People who do construction work are holding themselves out as a contractor, as someone who does contracting work, which is the gravamen of an unlicensed. Because somebody who holds himself out, a person who's actually building something, is holding themselves out to be a contractor,
Okay,
under the definition of unlicensed contractor.
I think that's a possibility.
Yeah.
Mr. Silva, what do you normally do for a living? Are you employed by people to help them with buildings, or do you do something else?
I am actually a barber and a nurse.
A barber and a nurse. Okay. And how did you wind up working for Mr. Casamento?
He reached out needing some help moving things around because of his age, and that's it.
Okay, and Mr. Casamento, how do you know Mr. Silva?
He was referred to me by my daughter,
And how does your daughter know Mr. Silva?
Friend.
friend.
Okay, so,
I just needed some help.
so you say to your daughter, hey, you know anybody that could give me a
Give me
hand?
a hand doing this,
And,
besides my
and
action.
Mr. Silva pops up.
Right.
Okay. Wow.
Oh, and let me clarify. He said that if I was technically doing this for free, he would have never filed me a citation. That's
Yeah.
his
If he wasn't
actual
getting-
code.
If he wasn't getting paid, it would be okay, but being I was paying him, it's a problem. So I thought, Lincoln got rid of slave labor back in the 1800s.
Well, I mean, and the county's position is that if this was a freebie from a neighbor who says, sure, I'll help you build it, you're good to go?
So if he's not paying him as defined in Florida Statute 489, which governs the construction industry, then he's not legally a contractor, as that defines it. The problem is, though, initially when I arrived at the property, Mr. Casamento was not even present at the property. You were out away retrieving
I
lumber.
was retrieving lumber.
Mr. Silva and his brother were at the property constructing the deck, not just helping, but constructing the deck, as you can see from exhibit number 3.
I'm doing the supervision, and it states that as long as I supervise
And tell us.
And it also
all the
states,
work. I mean, I'm sorry, I was getting.
I'm not going to let you guys argue among yourselves, but
I'm not arguing.
But in fact, I think when you read that long page, it does tell you that you need to directly supervise.
Right, but, I mean, I went to get lumber.
Yeah.
I'm sorry that happened. You just happened to pop up the one moment or 1 hour that I was missing.
I mean, it's a technical violation. You weren't there, he comes along and sees them, and,
But then they called me, I came back with the lumber. He noticed that I had a van full of lumber when I got back.
and your contention is that, Mr. Fisher, that under no circumstance except as a gift, as a friend, Mr. Silva could help,
correct.
okay?
Unfortunately, the violation is clear. What defines a contractor is someone who's receiving payment in response to performing services related to the construction industry, as you can
There's
see
no
here.
contract. I'm sorry, but I.
Unfortunately, as he's paying Mr. Silva, and Mr. Silva is helping and performing the work being done, and he does not have a license
Yeah,
for
no, I get
what's
that
needed
part,
is the
too.
reason why the citation was issued.
Okay, I hate this, but I am going to find a violation. The violation, I understand it. And I can tell you, Mr. Fisher, this is as far as I have ever seen this statute taken. But there is technically a violation. Yep, there is. And you can cure it in the future simply by not paying Mr. Silver or anyone else.
There's no record of me.
You'll figure that out. I'm sure you will. But nonetheless, based on the evidence, I'm going to find that the violation does exist. And I'm going to uphold the citation.
So this gentleman cannot come to provide for his family. He's got to work for nothing. That's basically.
Well,
now on top of everything else, he's got to pay a $500.
like I said, you'll figure that out. I'm sure that if Mr. Silva wants to continue helping you, you'll figure it out, or you may find somebody else. But so long as the evidence indicates that the violation existed. So,
What is the violation? That I wasn't there at that moment?
that's part of it, but the other part was that you paid him and he's not a contractor. It's,
As you said, I mean, you're 70 years old, I'm almost 70 years old. You need help to do the.
I
Okay.
Totally get it.
Whatever,
totally get it.
I don't
All right.
think it's proper, but, what am I gonna
Fair,
do?
but
Yeah. It's,
As you said, it's
So then
really
you-
taking it to the extreme.
let me ask you a question. So I would need to hold insurance or a bodily, what he said about the insurance thing, even if I was helping for 2 days? You can't even get insurance within 2 days to get accepted to even work anywhere as
no, you
workers'
can't.
comp.
But the contractor licenses have got a whole series of things that you would be required to do, work comp and other things, but
Your Honor,
But that's not the
my
issue.
other question
But
is,
what can you do for it? Sorry.
Well, wait a minute. You've got two other jobs. You're a barber and a nurse.
Kids, that still doesn't hold up.
You want to be a contractor, you go figure out how to be a contractor, but
That's what I'm asking.
that's not, and I'm not here to tell you how to be a contractor. I'm just looking at the statute and at the violation and what was done. So that's
Provide
it.
Mr. Silva, the contractor's information, post this.
Okay.
And how to obtain a license.
Yeah, okay. I'm going to call this case. I think it's done. I'm going to uphold the violation.
I understand, I just want to
But-
clarify a couple of things for my own head.
It won't be necessarily with me.
I understand, but I'm the homeowner, right?
Yes,
Why is he being violated? I mean, fined?
because he was the one that was caught doing the work without a license.
I think he caught me with a drill in my hand. I wasn't doing no work.
It's done. We're done. Thank you.
Thank you.
Have a good day. Take care. Okay. All right. Sorry, everyone, these cases are just taking a little longer than usual. All right, I'm going to call the Copeland case, Lisa Copeland. It's case ENF 2024-090453. Ms. Copeland, is that you? All right, okay. This is a violation case. We're going to hear from the county first. They make what the law calls a prima facie case, meaning if everything they say is accurate and correct and shows me that a violation exists, then it's the burden then comes over to you, and I'll swear you in, and we'll go from there, okay? Okay. All right, so Ms. Carrasco, if you'll raise your right hand whenever you find that one.
What is that?
You good?
Yes, sir.
All right. Do you swear or affirm the testimony you're about to give will be the truth, all truth, and nothing but the truth? So help you God.
I do.
All right. Whenever you're ready.
My name is Deborah Carrasco, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Lisa Copeland, is here. The case concerns a property at 3410 Southwest Noble Avenue, Palm City, Florida, in Martin County, Florida. The case was not generated from anonymous complaint. According to the official records of the property appraiser, the property owner is Lisa Copeland. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On September 17th, 2024, Code Compliance Investigator Kelly Switzer inspected the property. At that time, she observed the property and found a camper hooked up with power, sewer, and water, along with dock pilings and other trash and debris along the side of the property. At that time, she also photographed the property. The photographs accurately show what she saw then are marked as County's Exhibits 2 through 6. So those are the pilings in front of the house. Another picture of the pilings.
Are those pilings, are they on public right-of-way?
They are.
Okay.
Number 5 is the camper. And the other side of the camper. Based upon the investigation, she issued a notice of violation to Lisa Copeland on September 24th, 2024, marked as County's Exhibit 7. In the notice, she cited the following Martin County Code violations: Section 3201C, 2H, accessory uses, RVs by zone district land development regulations, Martin County, Florida, and Section 67201B, nuisance declared trash, general ordinances of Martin County.
Okay.
In the notice of violation, the respondent was given until October 22nd, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on October 28th, 2024, and is marked as County's Exhibit 8. The return receipt was not received, and November 27th, I posted the property and the county admin building. The affidavit of posting is marked as County's Exhibit 9. It was at that time Lisa Copeland requested an adjournment of the hearing to be today, January 15th, 2025. On January 2nd, 2025, an amended notice of hearing was generated. It was dated to be mailed on 1/3/25. I also generated an amended affidavit of posting and posted the property and the county administration building on the same day. The photographs are marked as County's Exhibits 10 through 12. And that's when I posted the property.
Okay, that's 12? Yep.
Yes, sir.
Okay.
I again went to the property on January 14th and saw that the cited violations had not been corrected. The photographs accurately show what I saw at that time and are marked as County's Exhibits 13 through 17.
Okay, 13,
So yeah, these are some other, he moved them from, they were closer to the roadway, he moved them to the side of a garage. So it's these items back in here.
Okay.
And then this is the pilings again.
are still,
Yep, as of yesterday. And this is the trailer, or the RV, both sides of it.
okay, is that trailer, is that in the front yard?
It's in the,
On the side.
It's on the side
Side,
of the house, but yeah. I request that all of the county's exhibits be received into evidence based upon the testimony and evidence. I request that the respondent, Lisa Copeland, be ordered to comply with the cited provisions of Martin County Code by February 28th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right, I'm sorry, the date you set for compliance is,
November 28th, 2025. I'm sorry, February. February.
February.
Yes,
I was going to
February.
say, November's a long time.
Yes, it is.
Oh, yeah, that sounds good to me.
I'm sure.
Okay. Ms. Copeland, if you raise your right hand. Sir, you going to have any evidence to give or no? Okay. All right. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
And your full names
Lisa Ann Copeland.
and your address?
I own this property. I don't reside there full-time.
Where do you
I
reside?
reside at 8419 Southeast Croft Circle in Hope Sound.
Okay. And sir, your full name?
John Whitelock, tell him
And where do you reside?
at that property.
Okay, this property, the one we're looking at.
Yes.
Okay, and what is your, and that's your affiliation with Ms.
We are
Copeland?
boyfriend and girlfriend for 15 years.
Okay, got it. All right, good. Okay. Any objection to my accepting into evidence the county's exhibits 1 through 17 in this case?
No, sir. I
so-
was aware of the.
Wait a minute, without objection, I'm going to accept into evidence the county's exhibits 1 through 17. Now we
Yeah,
can
yes,
talk about it.
okay.
Okay. So tell me.
So I was not, I did not get notice of this today's hearing. I was aware, I did get at my residence the December hearing. I did contact John, letting him know that I was in a serious car accident on December the 15th. I got rear-ended at a stoplight doing at 45 miles an hour. I am still in severe pain, and I've, not gotten a lot done in the last month, to put it lightly. I did not know about this hearing until 2 days ago. I just would like to go back a little bit as far as the pilings and the other. It's not trash, for one thing. These are very expensive, brand-new pilings. I also own a property at the end of Noble Avenue with a dock. I was issued a permit May 2021. I renewed the permit.
Your Honor, I would object to any testimony about this other case. That has nothing to, we've
that's-
already actually heard that case.
Well, that's why the pilings are in the front yard. I was.
Let me just respond to
Okay.
to Mr. Tui. If there is some relevance between why the pilings are here, and I will hear it. Okay.
Okay, so, I'm very offended that this is being called trash, because this is very expensive dock material. I was issued a permit in May of 2021 to repair an existing dock that I own at the end of this street with this property.
Let me just stop you.
Okay.
Just a minor point, and it
Okay.
may help you with your understanding. This section 67201B is a very broad section.
Okay.
And it starts with trash.
Okay,
And that's why when when the county talks about it,
Okay,
67201B, we all know as trash.
okay, well,
Well, but trash, and then it
Yeah.
goes on
very expensive
for like
trash.
very different points
Yes, sir.
of things, including materials
I understand.
that are placed there but not used at the time.
Yeah,
So,
thanks for clarifying.
I mean, otherwise, we all might look at that and say, oh, well, that just indicates that there's construction ongoing somewhere.
Yes.
But in fact, if it just sits there,
Right. Well, the reason
it
it's
falls
still
under
sitting there is,
67201B.
they issued me a permit and then took the permit back. We actually have a meeting with Commissioner Campry regarding this situation. So when they asked me to remove the pilings and dock material from the actual lot where the dock is, we had no other choice but to bring them to the residents. I don't know where else I'm supposed to do with this until we can get the permit reissued for what it's originally purchased for, was for the dock.
Wait a minute, why
So I'm kind of
did you
between a
move them?
rock and a hard place. I'm sorry.
Why did you move them?
Well, because they were at the property where the dock is at the end of the street, and then we were told that they had to be removed from that property.
Okay. Was there an order? Did either magistrate Werb or I issue an order that
No,
said there
no,
was a
sir.
violation?
We were just trying to comply with code enforcement. I've certainly,
Okay, but,
yes, we did what I had no other choice but to bring them there.
but
to
you
the-
moved them from one bad place to another bad.
Well, I think
that
they were, what I understood was because the land down there was so small. We moved them so it would
minute,
not
let me
be a
just hear
part
from
of
the
the
county.
easement,
Hang on.
and that was complied
You
with.
signed an order on the other property with the trash on the October 16th hearing of last year for the pilings, for the same reason they're there with no ongoing. That other case has been adjudicated, the permit has been denied, there won't be a permit issued for the dock on that property.
It's actually still ongoing. We have a meeting with the commissioner of why our permit was issued twice.
Three times.
It was renewed, and then when I went to renew the permit after actually getting the material, they denied the permit. So it was issued 3 times and then taken back, saying that now all of a sudden, there will be no permit. So here I am with all of this dock material, and it's still an ongoing process. We have a meeting with the commissioner regarding this situation.
When is your meeting?
We just were here actually yesterday and to plead our case in front of all the commissioners, and got a response from Commissioner Campy that they were arranging a meeting for us regarding this situation.
Okay, so you came and spoke under public comment?
We did yesterday, yes.
All right, it wasn't an agenda item.
No.
Okay, so you came and talked to
It was the only
commission.
way that we could just get the reason why I was issued a permit 3 times, and then all of a sudden, when I finally have the material to get the work done, they denied the permit, and now they're emphatic about telling me there'll never be a permit issued, which we just want to know why and how. How can you issue a permit 3 times and then all of a sudden say you're never going to get a permit? You're never going to be able to repair your dock? We have no answers, so that's what, we went to the commissioner for the answers.
In October, on October 16th, I issued an order that basically, I guess, talks about this other property and said, yeah, under 67201B, you can't have those poles there. You got to,
Yeah, well,
And
the
then-
poles
so
should
you
be in the
moved 'em
water
from
at
one-
our permit.
but you moved them from one property to the other.
I didn't know what else to do with them, sir. That's,
But,
I didn't,
okay,
Yes.
Your Honor, may I?
so,
sure.
We were told that the pilings were an eyesore to our neighbors and to move them from that location.
at the water.
So we moved them down to our property. and put them where they are at this moment. And with that said, the pilings should be in the water at this time.
All we want is to repair the dock
We-
and
we
put
were
the
told that
pilings
we
in
can't
the
even-
water where
Wait a
they're
minute.
supposed to
Can't
be.
both talk at the same time.
We were told that we can't even repair the dock after a hurricane broke it in half. I cannot repair a dock that's been there for over 25 years.
And that's what the county told you.
That's what they're telling us at
Okay.
this point, that we cannot even
That's
fix
why the
dock.
commissioner is,
And I don't know the answer to that, but I.
it's ongoing, sir.
Your Honor, if I can remind the court, at the October 16th hearing, the building director testified rather at length about the entire situation with the property and the dock and the denial of the permits, the issuance and then subsequent denial of the permits.
Sir, I was never given a reason for the denial of the permit after it being permitted to us 3 times. How can you deny
I
when you finally get the material to get the work done?
can't answer that, and I don't know the answer. It's not my purview.
And that's why I went to the commissioner, sir.
Okay. So I issued the order in October. You moved the pilings to this other property, basically, right? I got
Yes.
that right? Okay.
Yes.
All right.
Yes, sir.
Now, what about the other situation, and that's the campers in a stored state with no one residing on the camper?
Yes, sir. That camper is leaving, and it will be gone within 2 weeks. So I have made arrangements for that. Unfortunately, it couldn't happen before today's hearing. As I stated before, I never got the notice of today's hearing. As after my accident, I did not get the letter at my house about today's hearing. John didn't, I just found out about this. The camper is leaving and will be gone within 2 weeks.
Okay. All right, good.
Your Honor, if I
Let
can
me-
make a clarification on that,
Yes,
want to swear me in first?
sure. You've got a mic there, right? Okay. Do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Full name?
John
and-
Colondo, Code Enforcement Administrator.
Okay.
When the email came to me about the accident, I did respond to that one and said we would move it to today's hearing at that time, unless we decided to come into compliance. So I believe she was notified of today's hearing.
Right, you said it would be 30 days, but you didn't give me the exact date. I have the email. I can provide that email.
All right. It's not an issue because you are here,
Yes, sir.
so,
I did find out about it, but not in enough time to prepare what I would, normally come more prepared to
okay.
a hearing.
But honestly, I'm not sure there's anything to prepare. I mean, I can tell you that I've got an order that I issued in October that said, you got to get rid of the pilings.
From
And-
the other property, yes, sir.
From the other property. Well, you did that.
I did.
But you moved them to another property.
Yeah, we were hoping to get the permit resolved so the pilings could be in the water where they're supposed to be. And at this point, we're still working on that. So I'm still hopeful that I can repair the dock as was intended
I guess what I'm
3
telling you.
years ago.
I don't appreciate the cat and mouse. I
I-
mean, if you were going to remove the pilings, they should go to a proper storage area. I don't know where that is. That's up to you as the homeowner to figure that out.
Right,
Public right-of-way is not the right place to put it.
right.
I mean, and
My apologies
mean,
to the court, sir.
county absolutely could come and just take those away
Okay, yes, sir.
if they wanted.
I appreciate the time to come into compliance with that. February, the date will be sufficient for that. And I appreciate the time.
I'm going to find, based on everything I've heard, all the exhibits plus the testimony, that violations as charged do exist on the property. And I'm going to order you to comply on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Can I have time for that, sir?
It-
For the payment?
So ordered. It's due now. You pay
Could you
it.
give me some time to
I'll pay it.
pay the fine?
Your Honor, I'll pay the fine.
Yeah, okay, it's due now. So
Yes, sir.
that's the old one. There's the new one. We can actually give you a copy of this if you like. That way you can take it with you. We don't have to deal with,
Your Honor, may I have 2 minutes? Or 1 minute, please? I was told by Mr. Calando that if I moved the pilings from where they were and moved them up to the house, that would solve the problem for the property for where it is. And if at that point, they would issue another notice, which is what I said, fine. Hopefully, the permits will be taken care of by then. Because
I thought that was
nobody's been able to
sufficient.
give us an answer for why they took away the permits to begin with. There's some very shady stuff going on in this department over here, and we're trying to get to the bottom of it through the commissioners. I don't know exactly what it is, but we will get to the bottom of it. They're breaking some laws, and I'm not sure what they are, but we will get to the bottom of it.
how do you even suspect that?
I've got all their
Well-
emails, I've got all the correspondence.
We were
issued
just
3 permits.
issued 3 permits, yeah, so,
Okay.
yeah, that's beside the point for this court, and I apologize for
sure.
the outburst.
For sure. Do you have a response to,
I do. He is correct. I said that would, if he moved them from one property to another property, I would have to comply the one property. But I did tell him at that point, I would start a case on the other property. It is a cat and mouse, but I couldn't really do much else on that. But
We did.
And
I did tell him I would do that, and that's exactly what I did.
So we're not trying to play cat and mouse, we're trying to comply, and that's what we were told to do, and that's what we did.
okay,
We've got over $50,000 worth of building supplies sitting on our property because they took away permits that they had no right to take away. That's where we're standing right now. So if we're in violation for doing something wrong, I can assure you, they're doing a
okay.
lot more.
And you're gonna talk to your county commissioner, and
Yes.
we'll see how it plays out.
And-
Okay.
And you're still going to impose the fine.
Yes, sir. Yes, sir. The violation does exist. I don't appreciate the fact that 3 months later, it goes from one parcel to
He
another.
just told
parcel.
you that he told us that we could do that.
What he told you, and I heard, because I listened to it carefully, is that if you did do that, that he would initiate another case against you. But,
Your Honor, none of our neighbors are complaining. The only people who are complaining are them.
okay.
Not one complaint from a neighbor.
That's not relevant.
No, it is.
No, it is not relevant. The law is the law, the way the ordinance is constructed. So,
Thank you, sir.
good luck.
Where do I pay the fine?
Okay. The fourth case is Evelyn Comstock. And it's case ENF 2024-060615, also a violation case. And Ms. Espion, you're going to testify. Okay, and I'll get to you gentlemen in a minute. Ms. Espion, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, whenever you're ready.
My name is Maria Espeat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Evelyn R. Comstock, is not present. This case concerns a property at 4962 Southeast Pompano Terrace in Stuart, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint.
Wait a minute, did you say is not present?
Correct. These are relatives.
Okay, got it. Okay, but she's represented.
I am assuming so.
Okay, all right.
According to the official records of the property appraiser of Martin County, the property owner is Evelyn R. Comstock. A copy of the property appraiser's record of ownership is County's Exhibit 1. On June 18, 2024, Officer Counselor inspected the property. At that time, he observed trash, high grass, and an inoperable vehicle. At that time, he photographed the property. The photographs accurately show what he saw then and are marked as County's Exhibits 2 and 3. This is the trash. I believe this is an inop. Exhibit 3, some high grass in the back.
Okay.
Based upon the investigation, he issued a notice of violation to the owner on August 1st, 2024, marked as County's Exhibit 4. In the notice, he cited the following Martin County Code violation: Section 67.201B, nuisance declared trash, etc., General Ordinances, Martin County Code. Section 91.34A, generally inoperable vehicles, General Ordinances, Martin County Code. And Section 67.201A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until August 22nd, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. I took over the case in November and did a follow-up in November 8th, 2024, and seen the violation still remains, and found a new violation of a structure built without a permit. My inspection photos are marked as Exhibits 5 and 6. Here's the more trash. Right here is a structure, like an overhang connected to the house that had no permit. While I was on the property, the tenant said she would clean up and remove the unpermitted structure. On November 14, 2024, I amended the notice of violation, adding Section 105.1, permits when required incorporated by Section 21.1, General Ordinances, Martin County Code, with a new compliance date of December 16, 2024. The notice of violation, the amended notice of violation is County's Exhibit Number 7. Oh, I'm sorry, 6 was the other side of the boat on the inspection that shows it was inoperable. And number 7 is the amended notice. The unpermitted structure was removed, but the trash violation remained. Since compliance was not achieved, a notice of hearing was issued by certified mail December 17, 2024, marked as County's Exhibit 8. The return receipt was not returned, therefore, on December 30th, 2024, I posted the property and the Martin County Admin Building, and the affidavit of posting is marked as County's Exhibit 9. I went back again to the property on January 14th, 2025, and seen the violations still remained. At that time, I photographed the property. The photographs accurately show what I saw then and are marked as County's Exhibits 10 through 18. 10, the only violation that was corrected is that there's no longer an in-op as of yesterday.
Okay?
The boat is now on a trailer. Number 11 shows all the trash in the backyard and on the side. Number 12 is just a different view of the backyard with more trash on the side. Number 13 is a different angle of the yard showing the trash, wood, and other items. 14 in the backyard as well. 15 items in front of the vehicle. 16.
Looking at 15, is that not an inoperable vehicle?
They've covered it
And so it's allowed to be there?
as long as it's covered, it remains covered. 16.
Okay?
17 is from the backyard to the front yard photo of the trash on the side.
Okay.
And lastly, 18 showing that the in-op violation has been cured.
Okay.
I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I requested the respondent, Evelyn R. Comstock, be ordered to comply with the cited provisions of the Martin County Code by February 28th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requested the county be reimbursed this amount at the conclusion of today's hearing.
All right. Okay. You raise your right hands. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God? And your full name and address, sir?
Robert Comstock. I live, it's 9605 Libertas Way in Port St. Lucie, Florida.
Okay. And Mr. Comstock, what is your relationship
I'm
to the owner?
son This is my father.
Grandson, okay,
Comstock is my grandmother, obviously.
okay.
She's 99 years old.
And Mr. Comstock,
Gregory Comstock,
okay,
and I live at 1291 Southwest Sunshine Street in Stewart.
all right, and you're the owner's son?
Yes.
Okay. All right, you've heard the county and seen what they've presented as exhibits 1 through 18. Any objection to those?
No, sir.
Okay, so without objection, I'll order that those be accepted into evidence. What have you got to tell me?
So basically, we got a little bit of a unique situation that's going on here. As you're aware, it's my grandmother's home. She's 99 years old, mobility issues. My mother over here is her primary caretaker.
Does she reside there?
Yes, sir.
Yes.
Yes, sir.
Okay.
So she resides there. In February of 2022, my sister and her boyfriend came into some troubles, I guess you could say. So my grandmother agreed to let them stay at her house to get on their feet as, you know, just as a kind
Okay.
gesture. Shortly thereafter, my sister's boyfriend, his name is Michael, he started bringing just all kinds of stuff to the property. It's been an ongoing battle, you could say, with this gentleman to not bring these things to the house and do this to my grandmother's home. But we've had no luck with just trying to communicate with him civilly without going a legal route. But now that we've gotten to this stage of the game where it's now involving code enforcement and it's gotten to a level, as you can see from the photos, that's just absolutely disgusting, to say the least. It's really prompted us to take the next step to try to have him evicted from the property. So we have every intention of cleaning this up or giving him the chance to clean it up during this process. But we would like to ask for sufficient time, just because an eviction process could take some time, as everybody knows. And if he does not comply with, you know, removing the items himself, at that point, depending on how the eviction process goes, which I do have an attorney that's going to be helping with that whole situation. But
Have you actually filed an eviction?
we have not started the process yet, because I just recently was made aware of this whole situation by my mother. And that's sort of when I stepped in, like, you know, we need to do this, we need to do that, and these are the steps we need to take to rectify this situation. So we're going to be we're going to go ahead and file that eviction to start that process, and depending on what we get out of Michael, the person who owns all of this stuff, we may just bring in a dumpster and just fill it up and haul it off, because there is obviously nothing there that seems to be of value. And my guess is that, you know, since he's been doing this for 2 years and this has been ongoing since June, that he will probably not comply. So I'm just kind of looking to the future and thinking that that's how it's going to turn out, is that we're going to have to evict him and then
Okay.
pay to remove all of the items.
Let me just ask you again. Michael is your,
My sister's boyfriend, that my...
okay, they're not married.
No, sir.
Okay, and what is his last name?
Snodgrass, Snodgrass, if I'm correct. And his first name is Paul, too, I think.
Paul Michael Snodgrass.
Okay, and your sister's name?
Her name is Sarah Comstock.
S-A-R-A?
S-A-R-A-H. Yes, sir.
All right, so now, do Michael and Sarah continue to live on that property?
Yes, sir.
Yes, they're there right now.
Okay, so,
Both gonna be
so there's Grandmom Lisa, she's there.
Yes.
Grandmother lives there.
And Sarah and Michael. Anybody else? Oh,
My sister has a daughter from another man, and then Sarah and Michael also have a daughter. So it's the two of them,
and
two daughters.
two minors?
Yeah, two young girls, which adds to the uniqueness of the situation with evictions because it is involving kids, and it's
Okay.
really quite a ordeal.
Sounds like it.
going on.
All right.
But we have every intention of bringing this yard back to, and the home itself, because the home has some repairs that need to be made as well. And we have every intention of getting this property back to the state it used to be in, because my grandmother and grandfather built this home in 1978. And so the intention is to keep this home within the family as a generational home that, you know, will be passed down. It's in Rocky Point, a desirable area, and by no means do we agree that the condition of the home is what would be represented if he wasn't there.
Okay. Let me ask you, the county has suggested the end of February.
I
And-
feel that is not sufficient time just because of the eviction process.
Okay, do you have a thought as to what would be appropriate?
If you would agree to perhaps 60 or 90 days, because I've heard that kind of lines up with the eviction process. But again, you know, that whatever you feel is due, because we intend to leave here today and get over to the house and tell him, you know, we just left this hearing, this is where we are, get this stuff cleaned up. So I don't want to propose to him a lengthy amount of time because that could just add to the
He'll
complacency.
wait until the last day, like you said.
Let me ask the county, any objection to 60 days? To
Yes.
the end of March?
We would move for a continuance instead, Your Honor, for 60 days, to see if they can get this situation squared away.
Okay.
And then we can always bring it back at that time. We've heard everything, we wouldn't have to hear it again. So we would go to the end of April, continue it to continue it to the April.
Understand what the county is, that's actually a generous offer from the county, because, and I would tell you, actually what I told the other earlier gentleman, I've heard the evidence and I've heard the testimony. I would find, based on that, the two violations, based on the evidence that I'm seeing. So,
Of course, we're not.
so I'm not adjudicating it today, but I don't need to hear more evidence to do that.
Correct.
So if I continue this to the April hearing, which is
April 16th.
April 16th, okay. So I'm going to continue this to, let me just jot a note here, continue to 4/16. And either by that time, you will have cured the issue, come into compliance,
Correct.
or
Have a plan.
I'll adjudicate it that day.
Okay.
Okay, so, okay. I think that's, you'll get an order continuing it with a new hearing date.
Okay. So with the continuation, does that mean that the 575 is still due today, or is the whole?
No, it's withheld. It will be withheld until it's adjudicated. Let me just ask you, do we have good contact for you all? Do we have good? We have got
Yes, we do.
email, and so if we email you an order, a continuance order, you'll get it?
Yeah, I can share with
Yeah,
him. He's
well,
got email.
Yeah, and I have your email
We
as well.
can give everything to Maria.
Okay, all right, good. So that's how we'll send it out, and I'll, probably within the next day or so, I'll get the order out to the county.
Okay,
Okay,
thank
all
you,
right.
sir.
Okay, good luck.
Thank you.
Thank you for your time.
Oh, and by the way, at least for the short while, I am dismissing the charge of 91.5 34A, which was the generally inoperable vehicle. So that charge is gone. That leaves you with 67201A, weeds, and 67201B, trash.
Okay.
Okay, and
Road's going too, so.
yeah, okay,
Goes with it.
all right,
Everything's going.
okay, good,
But thank you very much.
all right.
Thank you, sir.
Okay. Let's see. All right. 5 is the Black Cane Rum case. Okay, it's the ENF 2024-040736. Respondent is Black Cane Rum. I can't wait to hear how that name comes about. It's a violation case, and we're gonna hear from the county. Officer Counselor is gonna testify again. You've been sworn in, Officer Counselor. And then I'll hear that part of the case, and then it'll flip over to you all. Okay.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondents, Black Cane Rum, are present. The case concerns the property at 9700 Southwest Fox Brown Road, which is located within Indiantown, located within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Black Cane Rum. A copy of the property appraiser's record of ownership is County Exhibit 1. On April 30th, 2024, Officer Frank Marcos inspected the property. At the time, he observed a commercial structure built without a permit. At the time he photographed the property, the photographs accurately show what he saw then and is marked as County Exhibits 2 and 3. 2 and 3. That's basically his hanging, but this is the structure in question back here.
Okay, and that's in Exhibit 2. Okay, got it. Exhibit 3 is like a door hanger?
Yes.
Okay.
Based upon the investigation, Officer Marcos issued a notice of violation to Black Cane Rum on June 7, 2024, marked as County Exhibit 4. The signature. In the notice he cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, as adopted by Section 21.1 General Ordinances to obtain a permit for the commercial structure. In the notice of violation, the respondent was given until July 8, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement. I took over the case on November 26, 2024. I reviewed the case and a permit had not been issued for the building. A screenshot of the property's permit history is County Exhibit 5. Basically, a permit was applied for, but was waiting on applicant, which basically means has not been issued.
Okay.
Since compliance was not achieved, a notice of hearing was issued by certified mail on November 26, 2024, and is marked as County Exhibit 6. The return receipt was not received, so on January 3rd, 2025, I posted the property. A photo of the posting and the affidavit of posting are County Exhibit 7 and 8. 7 is my posting on the front gate, and 8 is my affidavit of posting. No call or letter has been received in time, so therefore I went to the property again on January 14, 2025, and saw that the cited violation had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then, marked as County Exhibits 9 and 10, with a screenshot of the permit status as Exhibit 11. So Exhibit 9, the structure's still there. 10, just a side view of the structure. And Exhibit 11 showing that the permit still has not been issued.
Okay.
I request that all counties' exhibits be received into the evidence. Based upon the testimony and the evidence, I request that the respondent Black Cane Rum be ordered to comply with the cited provisions of the Martin County Code by February 28, 2025. If not in compliance by then, be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred the cost of $575 conducting today's investigation. And that concludes.
Okay. If you'll raise your right hands, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
and your full names and relationship to the property.
I'm Ignacio Rodriguez. I'm the owner, and she's Joan Rodriguez, my wife.
Okay?
She's the co-owner.
All right.
And I don't dispute anything that the county's saying. It's all true. It all began because of a misunderstanding. I thought that I was ag exempt, and actually, we did confirmation of that in January of last year. But then, like 3 months later, I think maybe it was due to showed up, and they told me that that area was not ag exempt. But I had already put the building up, thinking that I was ag exempt. So anyway, but that's fine. I wanted to get in compliance. I applied for the permit, and they came back with a number of issues that I didn't have a lot of this information because I didn't plan on having to get a permit. So we had a hearing here sometime I think in July or early August, and we met in this building, and everybody was, very gracious. They told me everything that I needed to do, and I immediately hired one of the things that they insisted on was a site plan. So I immediately hired Mathers Engineering, which they do this sort of thing, and they said that they could get me the site plan, they could get me the plans for the concrete slab. I already have the plans for the building, so we could get in compliance. The first thing that they asked me to do was to get a surveyor. And I went back to my regular surveyor, and they agreed that they would do it, but it took them like a month before they got out there. When they finally did it, they did it wrong, and then they gave the wrong information back to Mathers. Mathers had to send them back out to get the right elevations and that kind of thing. And then it's been in Mathers' hands. I have sent them several updates on the things that we need to do in the site map. And they, say, well, you're going to need this many parking spaces and all of that. And I'm full compliance with all of that. But the problem is that they didn't give me this site plan until last week. And it was all wrong. A lot of the things that we had talked about was not there. So I redid another site plan with the details that needed to be there. And they agreed that they were going to modify the site plan.
You want to show us that? We can put it down on the screen, on the tablet there.
So we agreed that we're going to do the site plan more according to this, because I need to bring in the sugar cane through here, process it here, and then the tractors need to be able to move around. So we need to be in compliance with 7 parking spaces, which we're going to put 5 here and 2 on this other side. But the site plan, we just met yesterday and went over the details of this. And, I'm at their mercy for them to come up with a site plan and,
To comply with the
and they have the preliminary hearing on the site plan so we can get all on the same page so that I can get in compliance.
Okay. Do I understand, I'm kind of piecing this together. Do I understand that you're going to manufacture rum?
Yes.
Where the name
We're
comes
going to
from?
do things a little different than other people are doing it. We're not going to use molasses. We're going to grow our own sugar cane.
Black cane. Some of it will be black cane, that's where the name
Yeah,
comes from.
well, we're going to grow our own sugar cane in the land, adjacent lands. I also own land on the other side of this site.
So there will be agricultural land?
Yes.
Just not this particular site?
We're going to be making rum with oranges and mango and the different types of sugar cane. But it's all going to be grown on site, and then everything except the rum will stay on site. So everything that, as you probably, I don't know if you know, but about 2/3 of a mash, when you make the fermentation, about 2/3 of that is waste, and 1/3 distills to 40% alcohol. That waste is going to be processed and brought back into the land, so that we don't lose any minerals and all the things that we would lose if we remove that waste permanently from the land.
I got it. Okay, that's
So, I mean, I know they want me to finish this by February. I'm still at the mercy of these other people. I have all met with them, fire marshal. I got the 2 companies working on the design. So I don't know if I can finish this by end of February.
Well, I mean, basically what the county is saying is you need to obtain a building permit for the structure. And if you just got the site plan wrong,
Yeah, hopefully they'll get.
site plan needs to be approved, right,
Yes.
by growth management.
Apparently, the respondent has been talking to growth management, and the building department has sort of been left out of the loop, so from my understanding is the building department doesn't know about any of this good stuff you've been doing.
Okay, so, county's suggesting the end of February. What are you looking at time-wise?
I don't know. Considering how slow these people have been moving, I don't know, maybe another month? End of March? And I'm gonna put a fire on them as soon as I leave here.
Well, my thought is that this probably is a minor site plan.
We're just in April, probably. It better make it, respondent seems to be, on top of stuff. He's relying on third parties that, he has only so much control over. April at the earliest,
The earliest.
and end of April.
Yeah, because once they present the site plan, I'm sure you guys are gonna come back with more changes, and we're gonna have to go back and forth.
You don't know what's going to come up, so that's why you got to leave time.
Trying.
But I'm trying, I really am. Just, it's a difficult process, putting together a distillery.
Drive you to drink.
Well, the problem is if I order you to obtain your building permit by April 30th, that's fine for everybody here, but that doesn't necessarily light a fire under the building department or growth management. I mean, you can take the order and show them, and I'm inclined to grant you at least until that time. If I went out further, then it's like 5 months. Let's say the end of April.
Okay.
To obtain a building permit. I mean, that's really what you need to do, because I'm based again on what I'm hearing, the county has made its case that you built the building without a permit. You didn't know you needed it, but you did. So,
Yeah, it was a misunderstanding. I even hired a lawyer that got a letter from the county saying that I could build, but he never sent me the whole letter. He sends me just a paragraph. Oh, you are cleared to build on A2 land, a distillery. But he didn't send me the full letter until afterwards, and then I realized, but you need a permit for the building, and you need this, and you need that. And the idiotic lawyer never sent me the whole letter until I requested it from him, after talking to the code enforcement people.
right. Okay. Anything else you need to tell me? Okay.
Ask me whatever you.
All right. Any objection to my accepting into evidence the county's exhibits 1 through 11 in this case? All right, so based on that, I'm going to find that it is appropriate to enter exhibits 1 through 11 into evidence. And based upon that evidence and your testimony in the counties, I'm going to find that a violation as charged does exist on the property, and I'm going to order compliance on or before April 30th, 2025, failing which a fine in the amount of $100 per day will accrue. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. So instead of February, it's going to be April 30th. And I am going to mark your drawing, if you will let us keep it. I'm going to mark it as Exhibit A for,
Okay, that's it's not a professional drawing.
no,
That's what they're.
but we used it and we talked about it, and any objection?
No objection.
All right, it's now respondents. I'll say number 1. Because the county normally numbers their exhibits. Okay, and that'll go into evidence as well. Okay, so when do you think you're going to get in production?
As soon as I get that permit, I'm on it. I mean, I got a lot of things to do on the outside, which we've been assembling the stuff inside, but we don't have electricity. We just have an extension cord to run the drills and things like that.
All right, well, good luck.
Thank you.
Thank you.
All righty, take care.
Definitely, hopefully by the end of the summer, I'm making some rum.
That'll be good.
Thank you, Your Honor.
Yes, ma'am.
No, absolutely not.
Okay, let's see. Yep, we're back at the top of the batting order. It's the Norelli case, Maria Norelli, and it's case ENF 2024-090047. And Officer Ampresetti, you're going to swear you in. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay.
Your Honor, this is a stipulated agreement.
It is a?
Stipulated.
Stip, okay. Yeah, it shows there's a violation case on the docket. Stip. Okay, and what have we got?
My name is Charles Ambrosetti, and I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Maria Norelli, is not present. This case concerns the property at 2921 Southwest Brighton Way, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Maria Norelli. A copy of the property appraiser's record of ownership is County's Exhibit 1. On September 3rd, 2024, an expired permit application letter was emailed to the contractor of record. A copy of that letter is marked as County's Exhibit 2. On September 6, 2024, I inspected the property. At that time, I observed a completed AC mini split without an issued permit. At that time, I photographed the property and left the door tag. The photographs accurately show what I saw then and are marked as County's Exhibits 3, 4, 5, and 6. Exhibit 3 is a front-facing photo of the property. Exhibit 4 is the door tag that I left the homeowner. Exhibit 5 is a photo of the mini split with the info tag matching the same model number on the application. Exhibit 6 is a top view of the AC mini split. Based upon the investigation, I issued a notice of violation to Maria Norelli on October 1st, 2024. It's marked as County's Exhibit 7. In the notice, I cited the following Martin County Code violation, Section 105.1, Florida Building Code, permits when required, incorporated by Section 21.1, General Ordinances, Martin County Code, for completed AC mini split without an issued permit. An amended notice of hearing was issued by certified mail on December 17th, 2024, and is marked as County's Exhibit 8. The owner entered into a stipulated agreement with the county on January 13th, 2025 to be in compliance by April 30th, 2025. The administrative fee in the amount of $350 has been paid in full.
Okay. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case. And I'm looking at the stipulation which recites the the facts as they were presented. And note for the record that $350 has been paid to the county. And that Maria Norelli has signed the stipulation electronically. And Officer Ambrosetta, you've signed on behalf of the county. I'm going to find that it is appropriate to enter into the stipulation or enter into the agreed order based on the stipulation and order compliance with the stipulation in agreed order.
Thank you, Your Honor.
Okay. Through H. Okay. Next is Officer Counselor. It's the Stephen Stanley case, and it's ENF 2024-060573. Respondent is Stephen Stanley.
Correct.
And Officer Counselor, whenever you're ready.
My name is Chris Counselor. I've been sworn in. I am a code compliance investigator for Martin County. The respondent, Stephen Stanley, is not present. This case concerns the property at 23901 Southwest Martin Highway, located within Okeechobee, located within Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser, the property owner is Stephen Stanley. A copy of the property appraiser's record of ownership is County Exhibit 1.
Okay.
On June 26, 2024, Officer Frank Marcos inspected the property. At the time, he observed an expired permit, BLD 2022-110463. At the time he photographed the property, photographs accurately show what he saw then. And so the expired permit letter will be Exhibit 2, with his photos being Exhibits 3 and 4. So this is the expired permit letter, which is why Officer Marcos is out to the property. Exhibit 3 is the structure in question. And Exhibit 4. Based upon the investigation, Officer Marcos issued a notice of violation to Stephen Stanley on August 1st, 2024, marked as County Exhibit 5. In the notice, he cited for the following Martin County Code violations: Section 105.1, Florida Building Code, Section 21.1, General Ordinances, to renew his expired building permit. In the notice of violation, the respondent was given until September 3rd, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. I took over the case in November of 2024. A review of the case showed that the permit was still expired. A screenshot of the permit history is County's Exhibit 6.
Okay.
Since compliance was not achieved, a notice of hearing was issued by certified mail on December 3rd, 2024, and it's marked as County Exhibit 7. Today's hearing date with my signature. The return receipt was not received, so on January 3rd, 2025, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 8 and 9. 8's the posting on the front gate of the property. 9 is my affidavit of posting. No call or letter has been received from the property owner. Therefore, I checked the permit status again on January 14th, 2024, and saw that the cited violation had not been corrected. A screenshot of the permit status is marked as County Exhibit 10, showing that the permit is still in an expired status. I request that all county's exhibits be received into the evidence, and based upon the testimony and evidence, I request that the respondent, Stephen Stanley, be ordered to comply with the cited provisions of the Martin County Code by February 28, 2025. If not, compliance by then be required to pay a fine in the amount of $100 per day until the violation is corrected. The county has incurred a cost in the amount of $575 conducting the investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing. And that concludes my testimony.
Okay, anybody here on behalf of Stephen Stanley? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 10. Officer Counselor, where is the concrete deck?
It's under said structure.
Okay. So the structure is not the problem.
Yeah, the expired permit is for the deck, the concrete deck underneath.
All right, and what kind of building is that? Like a barn?
From a previous case, it started out as a pole barn, so there's history to be reviewed on what's happened.
Okay. But then either somebody poured a concrete pad or,
Like I said, I have
Or
previous
it was
history with the case, and I know that it was the county citing him to, at the time, there was a pole barn there, and the permit that's expired is because we told him to get a concrete deck back in 2022. So that, he got the permit to correct that case, and now that permit expired, so.
gotcha. All right. Okay. So, again, without objection, I'll accept into evidence the county's exhibits 1 through 10 in the case. Based upon that evidence and your testimony, I'm going to find that a violation does exist on the property, order compliance on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Sir, thank you. Let's see. All right, the next one is the Sergio V. Nativi Living Trust. It's ENF 2024-100213. And Officer Carrasco, you're going to testify. You've already been sworn in.
Yes, sir. My name is Deborah Carrasco, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Sergio V. Nativi Living Trust, is not present. This case concerns the property at 1385 Northeast Flora Place, Jensen Beach, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property appraiser owner is Sergio V. Nativi Living Trust. A copy of the property appraiser's record of ownership is County's Exhibit 1. On October 14th, 2024, I inspected the property. At that time, I left a door tag regarding the expired application marked as County's Exhibit Number 2.
Okay.
Exhibit 3 is the notice of expired permit application. I returned to the property October 29th, 2024, and the girlfriend, she's either the girlfriend or the wife, confirmed the work was done but would not open the gate for me. Exhibit 4 shows what I saw at that time.
Okay, what are we looking at there?
I was just looking at the gate. She wouldn't let me in. She was standing right next to me, but she wouldn't open the gate.
Okay.
She did confirm the work was done.
And what work are we talking about?
The windows and the door,
Okay. But she did confirm the work was done.
correct.
Okay.
Based upon the investigation, I issued a notice of violation to Sergio V. Nativi Living Trust on November 14th, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 105.1, permits when required by incorporated by Section 21.1. In the notice of violation, the respondent was given until December 5th to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on December 9th, 2024, and is marked as County's Exhibit 6. The return receipt was not received. On January 2nd, 2025, I posted the property and the Martin County Admin Building. The affidavit of posting is marked as County's Exhibits 6 and 8. I'm sorry, 7 and 8. Yeah, so the affidavit of posting, and then when I posted the property.
Okay, got it.
No call or letter from the property owner was received within the time allowed. However, on January 9th of 2025, a revision to the application was submitted. It was denied and is back to, the status is back to waiting on applicant. On January 14th, 2025, I did research on the permit again. Exhibit 9 shows what I saw, which is the application waiting.
Not that anyone's going to read that, huh?
So it is there.
County change scanners or something? It's just like, I mean, I can see it on the laptop, but it's impossible to read it there. I don't know. Okay.
I request that all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Sergio V. Nativi Living Trust, be ordered to comply with the cited provision of the Martin County Code by February 28th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, looking out, anybody here on behalf of the Sergio V. Nativi Living Trust? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 9 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property and order compliance on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Thank you. And let's see, next case is the Scott Richards case. It's ENF 2024-101169. And Officer Switzer, you're going to testify. If you raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Whenever you're good to go.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Scott Richards, is not present. This case concerns the property at 18912 Southeast Hillcrest Drive, Tequesta, Florida 33469. This case was not generated from an anonymous complaint. According to the official records of the property appraiser, Martin County, the property owner is Scott Richards. A copy of the property appraiser's record of ownership is County's Exhibit 1. On October 29, 2024, I inspected the property, and at the time, I observed a vacant lot that had trash and overgrowth. At the time, I photographed the property, and the photographs accurately show what I saw then and is marked as County's Exhibits 2 through 4. There's some tall grass.
On 2,
3 is another angle of the property.
more tall grass.
Yep. And then 4 is the trash on the side of the property. Exhibit 5 is the aerial showing that the lot had previously been cleared. Based upon the investigation, I issued a notice of violation to Scott Richards on December 3rd, 2024. The notice of violation is marked as County's Exhibit 6. In the notice, I cited the following Martin County Code violations: Section 67.201A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code, and Section 67.201B, trash, nuisance declared trash, etc., general ordinances, Martin County Code. In the notice of violation, the respondent was given to December 24th to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on December 27th and is marked as County's Exhibit 7. The return receipt was not received, therefore I posted the property and at the administrative building. The postings and the affidavit of posting are marked as county's exhibits 8 and 9. My posting and my affidavit. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on December 14th, 2024, and saw the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then and is marked as county's exhibits 10 through 12.
And that's January 14th. Yes, sir.
January 14th, I'm sorry. Yep. So there's still more trash, tall grass, and then just another angle of the grass.
And the trash is still there?
Some, yes. A lot of it has been
That's
cleaned
in
up.
10.
Correct.
Okay. All right. Okay.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Scott Richards, be ordered to comply with the cited provisions of the Martin County Code by February 28th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony.
All righty. Anybody here on behalf of Scott Richards? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 12 in this case. Based upon that evidence and your testimony, I'll find that violations as charged do exist on the property and order compliance on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Okay, next one is the Stuart Archer and Penny Lynn Bergen Archer case. It's ENF 2024-110285, and that's also yours, Officer Switzer, whenever you're ready.
Okay. My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondents Stuart K. Archer and Penny Lynn Bergen Archer are not present. This case concerns a property at a vacant lot in Hobe Sound, Florida, 33455. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Stuart K. Archer and Penny Lynn Bergen Archer. A copy of the property appraiser's record of ownership is County's Exhibit 1. On November 13th, 2024, I inspected the property, and at the time, I observed a vacant lot that had trash and debris in the front of the property. At the time, I photographed the property, and the photographs accurately show what I saw then and is marked as County's Exhibits 2 through 4. This is a, not quite sure what it is, to be honest. The trailer, abandoned trailer, I guess.
Okay.
There's more trash and debris in front of the trailer, and that's just another angle. Based upon the investigation, I issued a notice of violation to Stuart K. Archer and Penny Lynn Bergen Archer on December 14th, 2024. The notice of violation is marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violation, Section 67.201B, nuisance declared, trash, etc., General Ordinances, Martin County Code. And the notice of violation was given until December 5th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved and a notice of hearing was issued by certified mail on December 11th, 2024 and is marked as County's Exhibit 6. The return receipt was returned as undeliverable, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as County's Exhibits 7 and 8. Oh,
Nope.
oh yeah, my posting is there in the very front of the property. And then my affidavit of posting.
Okay, got it.
No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on January 14th, 2025, and saw the cited violations had not been corrected. At the time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 9 through 11. So there's a little bit more trash accumulating. This is one angle from the front, and this is
Wait a minute, oh, let's see. So 9 shows,
this is in front of the trailer.
yeah, other folks are contributing to the
Yes.
file? Okay, and 10 is the
Just the
crazy
front angle.
trailer with a chair?
Yes.
11,
And 11 is the rear, the back angle.
got it.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondents, Stuart K. Archer and Penny Lynn Bergen Archer, be ordered to comply with the cited provisions of the Martin County Code by February 28, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony.
Anybody here on behalf of Stuart K. Archer or Penny Lynn Bergen Archer? Looking out, seeing no one. Without objection, I'll accept into evidence the county's exhibits 1 through 11 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property and order compliance on or before February 28th, 2025, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Thank you. Okay. All right. Bell South Telecommunications LLC. Ma Bell is back. All right, ENF 2024-110436. Officer Espiat, you're going to testify, and you've been sworn in.
Yes. My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Bell South Telecommunications LLC, is not present. This case concerns a vacant lot in the corner of Southeast Norman Street and Southeast Camino Avenue in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Bell South Telecommunications. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On November 20th, 2024, I inspected the property. At that time, I observed a vacant lot with high grass. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 2. And here's all the high grass.
Okay.
Based upon the investigation, I issued a notice of violation to Bell South Telecommunications LLC on November 22nd, 2024, marked as County's Exhibit 3. In the notice, I cited the following Martin County Code violation: Section 67.201A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code. In the notice of violation, the respondent was given until December 6, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail on December 17, 2024, and is marked as County's Exhibit 4. The return receipt was not received. Therefore, December 30th, 2024, I posted the property in the Martin County Admin Building. The affidavit of posting is marked as County's Exhibit 5. No call or letter from the property owner was received within the time allowed. Therefore, I went back again to the property on January 14, 2025, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then, marked as County's Exhibit 6. Here's the high grass, side view of it. I request that all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Bell South Telecommunications LLC, be ordered to comply with the cited provisions of the Martin County Code by February 28, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. Have you ever had any contact from them?
I have not, and the first time I went there, the gates were closed to that area you see there. And the second time, when I posted the property, they were open. So somebody does pass by there at some point.
Okay. All right. And that's where you posted on the fence?
Correct. There is some equipment behind the fence that belongs to BellSouth.
Yeah, I can see that in Exhibit 6. All right. So anybody here on behalf of Bell South Telecommunications LLC? Seeing no one, without objection, I'll accept into evidence the county's Exhibits 1 through 6 in this case. Based upon that evidence and your testimony, I'll find that violation as charged does exist on the property in order compliance on or before February 28, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
So ordered. You're welcome. Thank you. Gosh, they've owned that property for a long time. The deed says 1984. Okay, let's see. David Briggs, and it's a fine reduction request and stipulation and agreed order. Okay, so this is case number 10-0035834, and the respondent is David A. Briggs, and it's a request for fine reduction stipulation. Go ahead. Ms. Bradley, I didn't swear you in yet.
No, sir.
I think I swore everybody else in the room, but you raise your right hand. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, what do we got?
Okay, my name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 18397 Southeast Heritage Drive, Tequesta, in Martin County, Florida. On May 19th, 2010, an order finding violation was issued by the code enforcement magistrate to David A. Briggs for Section 105.1 Florida Building Code FBC required by Section 21.1 General Ordinances Martin County Code and Section 21.105 Swimming Pools General Ordinances Martin County Code. So Exhibit 1 is going to show actually the new owner. Mr. Gordon has taken over the property.
You know what's scary? I signed that order.
Mm-hmm.
May
You
of
did.
2010.
You did. Exhibit 2 is a copy of the original executed order by you.
Okay.
Compliance was required by June 24th, 2010. On September 13th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $519,500. Exhibit 3 is the affidavit of compliance with fines. Aaron Gordon is the current owner of the property pursuant to a warranty deed recorded in Official Records Book 3445, page 1642, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay $51,950 to resolve the outstanding fine which has accrued. And Exhibit 4 is Mr. Gordon's request for the reduction.
Okay. All right. And let's see, Exhibit 3, affidavit of compliance. And Exhibit 4. Okay.
And that concludes my testimony
All
for
right.
this one.
So without objection, I'll accept into evidence the county's Exhibits 1 through 4 in this case. And looking at the stipulation, note that it recites the facts as you have stated them. And also note for the record that Aaron Gordon has signed the document electronically. Ms. Bradley, I don't see your signature, but I'll bet you'd be happy to sign it.
I will be.
Need a pen? I forgot my pen this morning and had to get one from Miss Bradley. Thank you. Okay, note for the record that Miss Bradley is now signed on behalf of the county. And so and I'm going to actually date that for you. It's
Oh, I forgot, I'm sorry.
15/25.
Telling you.
I'll go ahead and execute the agreed recommended order. Okay. All right, let's see. All right, there's another Briggs
Yes, sir.
case. Okay, this is case number 2023, ENF 2023-03-0944. David A. Briggs is the respondent. And again, you've been sworn, so.
Yes. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 18397 Southeast Heritage Drive, Tequesta, in Martin County, Florida. On July 18th, 2023, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to David A. Briggs for Section 67201A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code, Section 21.99, accessory structures, General Ordinances, Martin County Code, and Section 21.110, exterior structures, General Ordinances, Martin County Code. So Exhibit 1 is the property appraiser, also showing that Aaron Gordon is the current owner. Exhibit 2 is the recorded stipulation agreement that was put in place with Mr. Briggs, also signed by yourself.
Yes.
Compliance was required by September 29th, 2023. On June 24th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $80,100. The affidavit of compliance is Exhibit 3. Aaron Gordon is the current owner of the property pursuant to a warranty deed recorded in Official Record Book 3445, page 1642, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay $8,010 to resolve the outstanding fines which have accrued. And Exhibit 4 is the same reduction request, showing Mr. Gordon agreeing to the 10%.
Okay.
And that concludes my testimony for this one.
All right, so without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. Based upon that evidence in your testimony, I'll find that it is appropriate to enter into the agreed order based on the stipulation that Mr. Aaron Gordon, is that correct?
Yes, sir.
Aaron Gordon agrees to pay the fine, reduced fine in the amount of $8,010. And this is an agreed recommended order to the county commission. Again, I note that Mr. Gordon has signed electronically, and Ms. Bradley, if you'll go ahead and sign and date, that would be great. Okay, so the document is now executed, and I will go ahead and approve and sign the agreed recommended order. Okay. And let's see, we've got one more case, the Wojciak case, Aaron and Jennifer Wojciak. It's ENF 2024-101099. And Ms. Bush, that's your case. If you'll raise your right hand, do you swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All righty, good. Whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I am a co-compliance investigator for Martin County. The respondents, Aaron and Jennifer Wojciak, is not present. The respondent has entered into a stipulation of agreement. This case concerns the property at 1582 Northeast Marine Court in Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraiser of Martin County, the property owner is Aaron and Jennifer Wojciak. A copy of the property appraiser's record of ownership is County's Exhibit 1. On November 6, 2024, an inspection was conducted at the property, and at that time, I observed non-permitted work of a wooden structure. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 4.
What is that?
I don't know.
I don't either. Bunch of pilings. Okay.
Exhibit 3, additional building material. And Exhibit 4.
Okay.
Based upon the investigation, I issued a notice of violation to Aaron and Jennifer Wojciak on November 7, 2024, marked as County's Exhibit 4. And in the notice, I cited the following Martin County Code violation. Section 105.1 FBC permits when required incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until December 9th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved and a notice of hearing was issued by certified mail on December 30th, 2024 and is marked as County's Exhibit 5. On January 10th, 2025, the respondent entered into a stipulation of agreement. The owner agrees to come into compliance with the cited provisions of the Martin County Code by May 30th, 2025, and if not in compliance with the cited provisions of the Martin County Code, by then be required to pay a fine in the amount of $100 per day for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I request that all the county's exhibits be received into evidence.
Okay, without objection, I'll accept into evidence the county's exhibits 1 through 5 in this case. Based upon that evidence and the stipulation in front of me, I find that it is appropriate to enter into the agreed order based upon the compliance date of May 30th, 2025, the payment of $350 in administrative costs, and a potential fine in the amount of $100 per day for failure to comply. Note that the stipulation is signed by Aaron Wojciak and Jennifer Wojciak and Officer Bush on behalf of the county. And I'll go ahead and enter the agreed order.
Your Honor, just a correction for the record of a Scrivener's error. There's actually 6 exhibits here. Exhibit 4 appears twice in the list, but.
Oh, yeah. So we got 4 and 4A.
Yeah.
All right. So 1 is the property appraiser. 2, 3, and 4 are photos. 4A now is notice of violation, and 5 is the notice of hearing. Okay.
That'll work too.
Still 1 through 5.
Now it is.
Okay. Very good. Okay, thank you. All righty, and let's see, I note too that we've got a set of minutes for the December hearing, which I have reviewed. And actually, I haven't reviewed them thoroughly, and I note that Officer Kalanda, you haven't signed either. I'm gonna withhold these and just bring them to the February hearing. Lord willing, I'll be here, and hopefully by that time I will have gone through them completely. Okay, so note that's going to be to February hearing. All right, anything else to come before us today?
No, Your Honor.
Okay, great. Thank you very much. We'll see you at the February hearing, which is, say again?
19th.
The 19th of February. Okay, very good. We stand adjourned.